5 seconds to go. Start. It was so to be urged by the learned SG that most of the houses which were demolished since the constructions were found to be in breach of the local municipal laws. It was submitted that the houses were demolished since they are found to be in violation of either the provisions of municipal law governing them or the panchayat laws governing such construction. The learned SG submitted that in some cases it may be by sheer coincidence that the properties which were in breach of local municipal laws governing them also happened to belong to accused persons. He, however, reiterated that it was the stand of various states that such properties can be demolished only in accordance with the procedure prescribed by law. The position is disputed by the learned counsels appearing on behalf of the petitioners applicants. It is stated that the chain of events clearly depicts that the demolition of the houses was an immediate reflection of the persons being implicated in crimes. It was submitted that the time gap between the person being named as an accused and demolition of his properties made it apparent that the punishment of demolition was inflicted by the executive on such person being arraigned as an accused. It was also submitted that in case of demolition of the property of an alleged accused, it is difficult to believe that only a single construction belonging to an accused is unauthorized construction, whereas all other structures in the vicinity are legal and authorized as per local laws. Though the learned SG may be right in submitting that in some cases it may be by sheer coincidence that the properties which were in breach of local municipal laws governing them also happen to belong to the accused persons. However, when a particular structure is chosen all of a sudden for demolition and the rest of the similarly situated structures in the same vicinity are not even being touched, malafide may loom large. In such cases, where the authorities indulge into arbitrary pick and choose of the structures, and it is established that soon before initiation of such an action, an occupant of the structure was found to be involved in a criminal case, a presumption could be drawn that the real motive for such demolition proceedings was not the illegal structure but an action of penalizing the accused without even trying him before the court of law. No doubt such a presumption could be rebuttable. The authorities will have to satisfy the court that it did not intend to penalize a person accused by demolishing the structure. While considering the issue with regard to the demolition of the houses which are required to be demolished for breach of the local laws, we find that the principle of the rule of law needs to be considered even in the municipal laws. There may be certain unauthorized constructions which could be compoundable. There may be certain constructions wherein only part of the construction is required to be removed. In such cases, the extreme step of demolition of the house property, would, in our view, be disproportionate. As already discussed herein above, the right to shelter is one of the facets of Article 21 of the Constitution. If the persons are to be dishoused, then for taking such steps, the concerned authorities must satisfy themselves that such an extreme step of demolition is only available, and other options, including compounding and demolition of only part of the house property, are not available. This court, in catena of cases, including the Constitution Bench cases of Modern Dental College and Research Center and others, versus State of Madhya Pradesh and others, K.S. Puttaswamy and another versus Union of India and others, and Vivek Narayan Sharma and others versus Union of India and others, has laid emphasis on the four-pronged test of proportionality. In the case of Modern Dental College and Research Center and others supra, this court observed thus, while examining as to whether the impugned provisions of the statute and rules amount to reasonable restrictions and are brought out in the interest of the general public, the exercise that is required to be undertaken is the balancing of fundamental right to carry on occupation on the one hand and the restrictions imposed on the other hand. This is what is known as doctrine of proportionality. Jurisprudentially, proportionality can be defined as the set of rules determining the necessary and sufficient conditions for limitation of a constitutionally protected right by a law to be constitutionally permissible. According to Aharon Barak, former Chief Justice Supreme Court of Israel, there are four subcomponents of proportionality which need to be satisfied. It is designated for a proper purpose. The measures undertaken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. The measures undertaken are necessary in that there are no alternative measures that may similarly achieve that same purpose with a lesser degree of limitation. And finally, there needs to be a proper relation, proportionality stricto sensu, or balancing between the importance of achieving the proper purpose and the social importance of preventing the limitation on the constitutional right. It is also to be noted that the construction of a house has an aspect of socio-economic rights. For an average citizen, the construction of a house is often the culmination of years of hard work, dreams, and aspirations. A house is not just a property but embodies the collective hopes of a family or individuals for stability, security, and a future. Having a house or a roof over one's head gives satisfaction to any person. It gives a sense of dignity and a sense of belonging. If this is to be taken away, then the authority must be satisfied that this is the only option available. Right to life is a fundamental right. As already discussed herein above, with the expanded scope of law, the right to shelter has also been considered as one of the facets of Article 21 of the Constitution. In one structure, various people, or maybe even a few families, could reside. The question that is required to be considered is as to whether, if only one of the residents of such a structure is an accused or convicted in a crime, could the authorities be permitted to demolish the entire structure, thereby removing the shelter from the heads of the persons who are not directly or indirectly related with the commission of crime. It is a settled principle of criminal jurisprudence as recognized in our country that a person is presumed to be innocent till he is held guilty. In our view, if demolition of a house is permitted wherein number of persons of a family or a few families reside only on the ground that one person residing in such a house is either an accused or convicted in the crime, it will amount to inflicting a collective punishment on the entire family or the families residing in such structure. In our considered view, our constitutional scheme and the criminal jurisprudence would never permit the same. In this respect, it will be apposite to refer to the following observations of Justice Krishna Iyer in the case of Gujarat Steel Tubes Limited and others versus Gujarat Steel Tubes Mazdoor Sabha and others. Stop.